Hello, I'm Ezra Amacher, the South Central Midwest editor at Insurance Journal.
Hi, everyone. I'm Elizabeth Blosfield, the deputy editor for Carrier Management.
And I'm Alan Laman. I'm a content editor at Insurance Journal.
Hey there, and welcome to a new episode of the Insurance Wrap-Up. Back here with Elizabeth and Alan. I'm Ezra, and today we're going to be looking at the topic of nuclear verdicts. In particular, we're looking at 7 of the top trending stories within the nuclear verdict space. Viewers of this video are well aware nuclear verdicts are an ongoing and intriguing issue for the insurance industry. They seem to be rising more and more each year and really affect insurers across the country. Today, we'll be going into some specifics about why we're seeing rising nuclear verdicts, as well as a couple particular cases or states where they're occurring in. So I think we're going to turn it first to Alan with our top story here.
Yeah, heck yeah. Great to be here with you guys, too. We're going to do kind of a new spin on our typical wrap-ups today. So excited to kind of pose some questions to each of us on the panel. It's been fun doing all these with you guys for like the past, past year or so, really. Now we've really been racking them up. But yeah, with the first one here, I will kick us off with a big story that ran on the Insurance Journal website not too long ago that I put together. And so that story really examines the question of what if there was a step-by-step process that defense lawyers could use to defuse nuclear verdicts right now. Leaders at Tyson & Mendez, one of the largest insurance defense-focused law firms in the country, say that there is. 2 of the firm's partners are preparing to release a book titled Nuclear Verdicts, The Apex, Break the Pattern, in which they share a 4-part strategy and the data behind it that they say has a proven track record of skirting these $10 million plus jury awards that we're going to be talking about today. For this piece, I interviewed Bob Tyson and Casey Lynch, who are the book's co-authors and partners at the firm, for a story about the strategy that was published on our website. Bob told me after analyzing court transcripts for more than 100 nuclear verdicts, his team hadn't found a single one where defense counsel had utilized all 4 of the following techniques. Those techniques are, number 1, the defense must accept responsibility. Number 2, the defense must give a jury award number. Number 3, the defense must personalize the defendant. And number 4, the defense must argue non-economic damages, which are commonly referred to as pain and suffering. These all constitute what Tyson & Mendez call the Apex, which is their litigation and trial strategy designed to combat what the firm describes as the rise of outsized and unjust nuclear verdicts. I think maybe most interesting in all this, Bob gave me numbers showing that essentially defense counsel doesn't do any given one of those 4 things in the majority of jury trials.
From the response already online, you can tell that this book's going to be very popular among the legal community, as well as people just work in insurance. And I'm curious what you think that the response will be from people who read the Apex.
From what I understand, the firsthand experiences that Tyson documented in his first book, which is called Nuclear Verdicts, Defending Justice for All, the feedback that he got from that, it was well received by both insurers and defense lawyers. So what Bob told me in our interview was that they wanted to see the data backing up the strategies that he outlined in there. And it's my understanding that's the goal of this new book. So it will be really interesting to see how it lands in that community.
Most definitely.
I do have a question for you guys regarding this, because I am excited to read this book when it comes out on October 22nd. I wanted to see if you would be interested in being in a book club with me so we could go through this and just wrap our heads around this and kind of deepen our own expertise.
Yes, absolutely. Yes. An insurance book club. What could be better? I'm on board.
Do you any recommendations top of your head, or you got to do some homework on what are we reading first here?
Yeah, well, I think maybe a good one to start off with would just be this book right here, the upcoming Tyson & Mendez book, and then we can, I don't know, maybe take a hard shift toward literary fiction or wherever we want to head next.
Are there any fictional books that center an insurance main character? I haven't come across any, but I'm sure there have to be some. We'll have to figure that out.
That's a really good question. Was anybody in Death of a Salesman? Was insurance involved in that? I can't remember. I'm thinking maybe
that would be the closest one. That may have to be the next one on our list so we can find out.
I think that's a play too. Maybe we'll fly out to your neck of the woods, Elizabeth, and see if we can see if it's on Broadway or off Broadway somewhere.
Yeah, come on out. Let's do it.
That'd be awesome. Hey, remind me, when does the Apex come out?
So this book, it comes out on October 22nd right now. And I think if anybody wants more information about it, like I said, we've got a pretty comprehensive story up on the IJ website. And then also the Tyson & Mendez website, they have a pretty good breakdown of everything too. So also just another reminder that Bob does have another book already called Nuclear Verdicts, Defending Justice for All. So could be some pre-reading, I suppose, for all the book clubs out there like us getting ready to dive in.
Well, that's very cool, Alan. And yeah, I'm sure all of us will be wanting to read the Apex, as well as many of you listeners out there. So now we'll be turning our attention actually to commercial trucking, where there was a bill proposed that can make stage accidents a federal crime. HR 2622 was proposed earlier this year by Representatives Mike Collins of Georgia and Brandon Gill of Texas. And this bill would make it illegal to stage accidents, and it would enforce strict penalties on those who participate in these crimes. The bill would impose a heavy fine and the possibility of imprisonment for up to 20 years if someone was caught staging an accident involving a truck. And if bodily injury or death results from a staged accident, there could be an additional fine and jail time. Now, the Staged Accident Fraud Prevention Act, which is the official name of the bill, specifically targets accidents involving commercial trucks, since those can lead to costly, frivolous lawsuits. Damages often exceed 7 figures and can endanger other vehicles, drive up the cost of insurance, and can wipe out small business operations entirely. Louis Pugh, an executive vice president of Owner-Operator Independent Drivers Association, said that staged accidents are not victimless crimes. These are calculated, premeditated assaults that endanger lives, destroy livelihoods, and compromise highway safety, he said.
Yeah, this is really interesting, Ezra. I always see news about staged accidents in various states coming through on the news wires, and I know this is a big problem in the industry. Was there anything that stood out to you about this bill in particular from this article?
I think what stands out to me is maybe the dynamics behind why this is such an important topic. So especially in states like Texas and Louisiana, you have a lot of smaller auto fleets, commercial auto fleets that is, who are really just trying to get by. And with the rising cost of commercial auto insurance, as well as higher diesel fuel cost and other factors, they already face very small profit margins as it is. So when they're settled with potentially 7-figure settlements for accidents, that really taps into whether they can afford to stay afloat or not. Obviously, it drives up their insurance rates as it is, and the commercial insurance market has just gone up, I think, exponentially over the last half decade or so because of accidents, whether staged or not. So this is a way to kind of cut down on, again, some of those more frivolous lawsuits that are alleged to occur, especially in maybe those Gulf states there like Louisiana and Texas.
Yeah, that makes sense. So they're huge numbers. And as it said in the article, these aren't victimless crimes just because the accidents aren't actually occurring. So yeah, I think that's fascinating.
When I think of nuclear verdicts, I don't necessarily jump to fraud in my mind, when I start thinking about everything connected to them. So it's just interesting to see this piece kind of explore that connection there. Ezra, I know as the South Central and Texas editor for IJ, you do a great job of covering the state over there. Just wanted to see, are there any other fraud-related headlines that have caught your eye lately, specifically from Texas?
Well, there is one, and it actually ties to this very sector, and how fraud can really impact commercial trucking. So last year, the wife of a former San Antonio trucking magnate was sentenced in a multi-million-dollar fraud scheme. Her name is Frances Hall. She's a former co-owner of Bill Hall Jr. Trucking, and she was sentenced for her role in a scheme to avoid paying $9 million in workers' compensation premiums. Investigators with the Texas Department of Insurance confirmed that between over 7 years, Hall reported payroll information to her insurer, as well as concealed payroll reports to get lower insurance premiums on their gravel hauling business. So this was a case where someone who owned one of those fleets was avoiding paying the proper premium. And when that's occurring, it's going to, unfortunately, probably drive up the cost of insurance for everyone if some people weren't paying their share. And, she was caught and I think sentenced to prison for that. So that was one that certainly caught a lot of attention lately.
Yeah, I think this is all really interesting and kind of keeping the focus on the auto industry with sort of a heavy topic, recent vehicle-based terrorist attacks in New Orleans and Las Vegas and how they're affecting the insurance industry. Earlier this year, insurance analyst Ian Gutterman wrote an article originally published on Carrier Management in January that highlights an emerging and underappreciated liability risk for insurers and transportation companies. While terror-related property damage is often pretty well insured, Gutterman argues that liability coverage, especially in a legal environment that's prone to nuclear verdicts, is dangerously inadequate. Ride-sharing, delivery, and other services could face large claims if linked to these incidents, but they likely lack the necessary liability towers to actually withstand them. And this evolving risk underscores the need for insurers and brokers to reevaluate their coverage strategies for clients with vehicle exposure. I thought that this was an interesting article because what if, these apps and online platforms that so many of us are so used to using are actually used to commit acts of violence or terrorism? You don't want to think about that, but it's an important topic to consider, and, how these companies should be preparing, what ethical responsibility insurers have when pricing or denying coverage for these risks. Alan or Ezra, I was curious if you were seeing any talk about this in the industry yet, because these were new questions to me when I was reading this article.
I remember when this happened, it was New Year's Day where we had kind of coinciding attacks, both involving I think the Turo auto share company. And there's a lot of questions about kind of who is at fault in this situation. Is it the owner of the vehicle who lends the car, or is it Turo itself, the company who is providing the cars, or is it the person who's responsible for the attack? And I think a lot of that is still maybe being decided both in courts as well as interesting case law, because there's not really a lot of precedent for this kind of company until very recently, where you're lending a car similar to like an Airbnb style almost. I think it'd be really interesting to see what litigation, if any came out of this with Turo in particular. But definitely, one of those evolving risk landscapes I think people in auto are paying very close attention to right now. So.
Yeah, absolutely. No, my only follow-up question would kind of be alluding to what Ezra said there. I mean, do we know, Elizabeth, did Turo face any lawsuit or litigation after these attacks?
So I read reports about the company facing increased scrutiny and some legal questions in the wake of the attack, but I haven't seen a lawsuit yet. I know that Turo CEO Andre Haddad did say in a statement on the company website that, of course, the company's heart is with the victims and their families, and they're consulting with national security and counterterrorism experts to sort of learn more about how the company can get, better and play its part in helping prevent something like this in the future. So it sounds like they're thinking about it pretty deeply.
Yeah. And, just to follow up for you, Elizabeth, with your cyber background, I'm curious if you thought about if there's any cyber elements to this, of how that might play into these kind of incidents.
Yeah, that's a really good question. I think cyber is obviously touching every company these days. And I think, with terrorism risk, we'll likely see it more and more, at least from the conversations that I've had with insurers. Even for an episode of our video series for carrier management, Between the Lines, earlier this year, we talked about how cyber is becoming a bigger threat with geopolitical tensions rising and some of the global conflicts that we're seeing. And terrorism is unfortunately a part of that. So I think any company, including Turo, shouldn't rule out how to manage, cyber as a factor in these terrorism threats.
Most definitely. Well, now we're going to turn our attention towards corporate nuclear verdicts. Nuclear verdicts against corporate defendants reached a record high in 2024, according to a new report from research firm Marathon Strategies. The number of nuclear verdicts, those that surpass $10 million, rose to 135 in 2024, more than 50% over the previous year. Now, the total sum of those verdicts was $31.3 billion, which was over 100% more than the prior year. Now, keep in mind, these are only verdicts, not settlements. This doesn't mean all the money that was actually paid in these cases, but it does represent how corporations are facing higher and higher risk of having to pay enormous settlements here. One thing that kind of came out of this report is the idea of thermonuclear verdicts, which are verdicts of $100 million or more, and those increased to 49 total last year, with 5 of those resulting in verdicts of more than $1 billion. The report, which is Corporate Verdicts Go Thermonuclear 2025 edition, attributes the growth of nuclear verdicts to many factors, including corporate mistrust, social pessimism, erosion of tort reform, as well as public desensitization to large numbers. And Texas led all states with 23 nuclear verdicts, followed by California and Pennsylvania.
Yeah, that's just staggering, man. How many thermonuclear verdicts did you say there were?
49 last year, which is a huge increase, I believe, from the year before. But again, these are thermonuclear verdicts, are verdicts of $100 million or more, which, depending on the size of the business, could maybe wipe out an operation entirely. At the very least, it's going to be, a massive issue for those companies to have to pay those if they were to eventually be forced to.
For sure. Well, no, I mean, I think that number grabs me right away. And I know when we go through these reports, we're often bombarded with statistics and numbers and just a lot of information. I mean, when you were going through this one here and you were putting the story together, what like really grabbed you or really stood out to you?
Well, I think when you really dive into the numbers, what stood out is how many of these were product liability cases. I think product liability accounted for 32 of the nuclear verdicts for approximately $14 billion. Now, among these were the continued litigation against Bayer AG over its claims that its Roundup product causes non-Hodgkin's lymphoma, as well as cases against pharmaceuticals. Pharmaceuticals actually led all industries as far as nuclear verdicts. They were followed by technology, hardware, storage and peripherals, and trucking. So, the area that people are really focusing in on again are the product liability cases.
Very interesting.
Yeah, Ezra, this is all really interesting. You did a great job on your reporting on this, and the report, covers so much. I know we were talking about this ahead of this call, and we I don't know that we came to a conclusion, but what was interesting to me is that the report highlights state court producing nuclear verdicts. Did you find anything in this report or your other reporting on this topic about why state courts are more prone to these nuclear verdicts than federal courts?
Well, it does raise a very important question, I think, for corporations. A lot of time you hear they want to move litigation to a certain state or certain jurisdiction to avoid having to face different states' reputation for being really harsh on delivering nuclear verdicts. And some states they happen to have higher caps on the amount of damages, particularly punitive damages, which is where you see the numbers really pile up as a punitive case, of course. And that's especially true in cases like medical malpractice or product liability, as I said. So I think certain states, whether it's because of the population that lives there or just the way the state tort reform is or isn't enacted, are more inclined to deliver some of these astronomical numbers, so to speak. Whereas usually in federal cases, they move a little bit slower through the courts. And then two, there's usually more kind of safeguards put in place to prevent some of the enormous punitive damages that are awarded in certain state courts, but not all states, I should mention. So
yeah, that makes a lot of sense. And you've done so much reporting on this nuclear verdict topic. So I'm glad to be with you as an expert on this panel to answer our questions, because I don't know the answers to some of these. So that's really helpful. And, Alan, I'm happy to be here with you too. I know that we were together in person at RIM's Risk World in Chicago earlier this year. That was so fun. Sometimes we do get to go off screen and see each other actually in person. And
that's none of these boxes.
Yes, exactly. We were also with our colleague, Andrea Wells, who's our head of content, and she did so many great interviews while there. So did Alan. But one of Andrea's was with Alan Kirsch, Senior Vice President and Head of Claims and Judicial and Legislative Affairs at Zurich, North America. He talked about how social inflation, the rising cost of liability claims driven by jury awards and aggressive legal tactics, is impacting the insurance industry overall. So let's take a quick look at this clip from her interview.
We've talked a little bit about the differences, what's driving this legal abuse in the system today and its impacts on the industry. Maybe you can share that. And if you have any recommendations on how to mitigate this trend or solutions that you're advocating today.
Yeah, absolutely. So we stood up my team, and we're called Claims, Judicial and Legislative Affairs, about 4 years ago, to really act as a social inflation task force. So to really understand what exactly was driving it. We knew we were seeing this in the numbers, and our customers were certainly concerned when they saw larger and larger what we call nuclear verdicts in excess of $10 million. Seeing more and more of those was certainly a concern. So me and my team did dive into this to be like, what really is driving this? So as I mentioned before, probably the first thing, and we divide this into essentially 4 different buckets, is just the jury demographics, the changes we've seen over the years in the way that juries look at their role, the way they look at these types of cases. And as I said before, the anti-Corford bias. Another bucket was around plaintiff tactics. The plaintiffs' bar in this country is well organized, they're very well funded, and they're very good at sharing information. So there's a tactic that works. Traditionally, there was one called the reptile theory, which in essence creates a sense of fear or anger in the jury to really get them to award a larger amount. We've seen anchoring, so suggesting very large values for the case and getting the jury to be thinking and comfortable with those larger numbers, as well as the advertising we've seen. And I would say that's probably been the most prolific over the last several years, and a very distinct strategy behind the advertising. So talking about specific numbers, letting prospective jurors and prospective plaintiffs know or think that that's what these cases go for. So the advertising is another plaintiff tactics, and we include that in that bucket. And then the last 2 are really litigation funding. So third-party litigation funding has grown exponentially over the years. So these are private companies, usually backed by hedge funds, other investors looking to essentially invest in litigation. So they'll provide non-recourse loans to the plaintiffs in exchange for either some percentage or a very large interest rate at the end if they settle or if the case goes to trial. And then the 4th bucket is just the litigation environment we find ourselves in, eroding tort reform that we've seen over the years, and laws that have been designed to expand liability for defendants. There's other issues as well, but basically those are the four main drivers that we've seen.
Okay, great.
And in terms of mitigation, I can jump right into that.
Sure.
I mean, each one of those buckets, I would say, has a slightly different bit of mitigation. The first two I can maybe put together, and that is around just the changing juror demographics and the plaintiff tactics. So part of our role is to educate and train. So we work with our claims professionals, making sure they understand what these drivers are and what they can do for it. We work with our customers and our broker partners quite a bit on these as well. Early investigation, quick notice when there is a loss so that we can jump in and investigate properly. We want to make sure that we've preserved all the applicable evidence that's out there. Sometimes if you don't do that, there could be a problem down the road when you actually have to litigate a case if you haven't preserved the evidence properly. So, working with our customers as an example to make sure that they've done that properly. And really a lot of training with our defense attorneys as well. A lot of this are, as we say, litigation tactics. So it's happening in the courtroom. So our defense attorneys need to understand, and again, to give you an example, how to tell the defense story. Traditionally, defense attorneys would sort of pick apart the plaintiff's case, which is fine, but they also need to tell a story. What's the story that the defense is proposing here? Juries want to hear that. So we work with our defense attorneys to make sure that they're doing that they're making the complex simple so the jury can understand, where we're coming from and what this case is really about. So a lot of education and training for those first two drivers. For the second two drivers, what we did was about 4 years ago, we kickstarted an industry-wide coalition. And when I say industry, I mean, other carriers, of course, the broker community, our customers as well, really designed to prioritize the various tort reform issues that we see out there. So which jurisdictions, which issues we need to focus on. I would say most of these companies were sort of doing their own thing before then. Sometimes it aligned, sometimes it didn't. But by having this coalition, we can share information with each other much better and help set those priorities. And we've had some good successes over the years, I would say, and there's some really good momentum, not only on the third-party litigation funding front. When we started, there were maybe 2 or 3 jurisdictions that require disclosure, as an example. Now, we're above 15 or 16. So there's good momentum getting some regulation around third-party litigation funding. And in the tort reform angle, of course, Florida 2 years ago passed really historic tort reform, and really seeing some good objective numbers out of what the governor and the legislature in Florida wanted to do. Rates coming, either staying flat or coming down, more P&C companies coming into the market in Florida. Citizens, their insurer of last resort, seeing their policies come down. So all of the things that the governor and the legislator sought to do with tort reform are actually happening. So it's a great success story. And now recently, 2 weeks ago, Governor Kemp in Georgia just passed also very historic, comprehensive tort reform. I think taking the lead from Florida and seeing some of the benefit there. So we do see a lot of momentum building. We work with trade associations or other carriers. A lot of local trade associations as well, kind of our boots on the ground, just to educate the legislators, know them. What we're trying to do is really just level the playing field out there when it comes to personal injury litigation.
This was a really fascinating discussion. It actually reminded me of a panel discussion that I attended earlier this year for a XyWave conference. And a team of legal professionals was discussing the term social inflation itself. And they said something interesting that I hadn't considered, that we need to maybe come up with a better term, because some of the reason why we can't find solutions is because the language makes it more confusing as to what social inflation actually is. They suggested legal system abuse as more clear language around the issue, but I thought it was an interesting point that we don't really know how to tackle a problem until we know how to define it. So I was curious, Alan and Ezra, have you heard any talk about redefining the term social inflation in the industry, or was that sort of exclusive to that panel I attended?
That's a good question. I can't recall just off the top of my head if I have. Ezra, have you heard any discussion on this?
I think I'd heard similar to what how they define it there in the panel, Elizabeth. But I do think it speaks to the issue of how people who report on insurance or work in insurance, we're in a bit of a bubble as far as we have a good grasp on what these concepts mean, but then you go to a party or you go to your run club and people there have no idea what you're talking about when you say social inflation. And I'm always amazed too when you read reporting on the insurance industry outside of our area of expertise, and you don't really hear some of the terms that we come across daily mentioned in other publications that are more national in their reach. And I think it just speaks to maybe the language barrier that we operate in within insurance.
Yeah, we definitely get used to our own jargon, and then it kind of sounds probably to everyone else like we're speaking a different language. So that's a good point.
Well, I think like they're very slightly related to this, just this idea around the discussion of the topic on the whole. I mean, something that I've pulled away from my interviews with folks on the insurance defense side is that defense teams, they traditionally haven't really shared much about what's working for them with folks like outside of their team or outside of their organizations. When I hear stuff like that interview that we just played with Alan there, it makes me wonder if maybe this is beginning to change. I mean, did anything in that clip really stick with you or surprise you in any way, Elizabeth?
Yeah, just kind of talking about the language that's used in insurance. And I guess this is more on the legal side, but one concept he mentioned, the reptile theory. I had to look it up. I hadn't heard of it before, but it was interesting. It talks about how attorneys will sort of appeal to the primal instincts of the juries and their sense of self-preservation. So that involves sort of framing the defendant's actions as a threat to the safety of the jury, but also sort of the broader community as a whole. And I thought that was an interesting theory, I guess, in sort of understanding or wrapping your mind around social inflation and kind of figuring out how to tackle it as a problem. So that was one thing that stood out.
Yes, Elizabeth. Well, I had a phenomenal time just being at Risk World by RIMS with you there in May. Was that really? That was like almost 3 months ago now. That's just crazy. At that conference, you mentioned that we were both doing interviews. And in this next clip, we're going to show one of me with Jennifer Aker, who actually is a partner at the law firm that I mentioned in my first story, Tyson and Mendez. When I spoke with Jennifer, we talked a lot about the Apex method. And it was really interesting to hear her really outline in detail the 4 core tenets of the strategy in depth. So let's just take a quick look at what she had to say.
There are a lot of AI tools available, and we're using them sort of, on a case-by-case basis, because the insurance industry, they're aware that AI is out there. They're aware that the plaintiffs' lawyers are using it, and they know that they have to catch up or they're going to be left behind. But it's a little scary, right? We're still trying to develop the right rules. We're trying to stay ethical about it, and we're trying to figure out how to wrap that into their billing practices. So there's a lot going on, but there's a lot of great tools out there that can help with summaries, that can help with strategy, that can help with looking for specific words and records and really cutting down on the lawyer time so that we can focus more on strategy. Tyson and Mendez is taking a really cool approach, and we've got this new program that is supposed to be collaborative with the insurance industry. It's called Schaefer City, to identify nuclear verdicts long before they ever happen, just by using AI to review data from the file.
Wow, yeah, a lot of the things you talked about there. When I talked to Robert Tyson a little bit ago, he mentioned, how the plaintiffs bar is using AI in very similar ways. So it seems like, y'all are using it as a way to kind of keep up and to fight back against it.
We are definitely trying to keep up, and we are definitely trying to fight back on all these things. It's interesting because the way the plaintiffs' practice works, it's just a different practice. They don't have the same contractual relationships that we have with like the insurance carrier or with the insureds. And so they've got a little bit more of an opportunity to be creative and go outside of the box. We're kind of operating within the insurance box sometimes, and we're working all the time with our carriers to push those boundaries, and they're letting us a little, so it's a lot of fun.
But for the viewers who are watching today, what's something that you would want them to know about containing those verdicts and how they can do it?
I mean, we're not going to contain every single one, okay? But the number one thing to remember, and this is for everybody, insurance defense lawyers, all the way, through to the claims professionals, to our experts, everybody should understand the number one driver of a nuclear verdict is juror anger. And so what we're doing from literally day one of getting the case is we are trying to identify the risk factors for increasing jury anger, and we're trying to mitigate those. And Tyson and Mendez has developed a practice, we call it the Apex method, of trying to reduce jury anger throughout the phases of litigation. And it really just starts with being the most reasonable person in the room. We try to be polite. We try to be understanding of everybody's position. We understand that the plaintiffs have been through a hard time, and and we use our core methods of giving a number early and often, accepting some responsibility, personalizing our corporate defendant, and then of course we have our specialized way of arguing our non-economic damages. And we just take that right up the pyramid to the top, being the nicest person in the room, being reasonable, just being a person, right? We're not just these insurance defense robots and trying to appeal to the jury and to the plaintiff in large part in that way, and hope that in that process we diffuse jury anger and reduce the chances of a nuclear verdict.
Yeah, no, it's just super interesting information from the folks who are in the trenches, really focusing on this. So I thank you again for sharing that with us.
Absolutely. We're doing it every day.
Yeah. I think for this last question, I just wanted to ask you, are there any emerging types of claims or lawsuits that you think risk managers should be aware of or should be keeping their eye on right now?
Yes, kind of. So, I think that we're mostly in the personal injury space. And so the number of ways a person can be injured, slip and falls and trucking accidents and things like that. We see the same kinds of claims, but what we are seeing is the sort of the way that plaintiffs' lawyers are trying to find new people to sue, right? Where, for instance, in the trucking industry, in Texas anyway, we are seeing a lot more broker liability claims. So they're trying to hold parties that are further and further away from the accident responsible. And that's put a lot of pressure on the defense lawyers to always consider risk transfer, and we're constantly looking at contracts and trying to understand relationships. It also creates a space for us to work really closely with our insureds to make sure that they are as protected as they think they are, because the indemnity provision in a contract isn't always quite as clear as you think that it is. I also think that what's going to be happening because of the tariffs and because of a lot of the immigration issues that are currently out in the world, I think that there's going to be some delays. I think that there's going to be some contracts that are missed, and then I think that could affect the construction industry and certainly the trucking industry. And I think there's probably going to be some litigation from that, although I don't think we know exactly what that's going to look like right now.
That was a portion of a great interview, Ellen, that you did with Jennifer there. She talked about how juror anger is a big driver of nuclear verdicts. And, from your discussions with her and other folks, I'm curious, what are some of the root causes of that juror anger? And also, how does the insurance industry's own perception play into that anger among jurors?
I guess I apologize in advance if I butcher any of this from the Tyson folks, but I think what they would tell you is that they envision the apex as sort of a coin. So on one side of the coin, it can be the things that can be inflamed to really increase that juror anger. And on the other side of the coin, it's sort of the things that can be used to diffuse it. So when you look at their 4 points, the defense must accept responsibility, the defense must give a jury award number, the defense must personalize the defendant, and the defense must argue non-economic damages. If you sort of flip it and look at the other side, these are the things that plaintiffs' attorneys can use to sort of inflame that juror anger, to intensify it, at least in their strategy or in their understanding that they're going to be releasing with this book. I think, though, even if you just were to hone in on one of those, it seemed to me from my discussion with Bob that the first point, the point about accepting responsibility, is a huge part of it. He told me in our interview that in media interviews following these nuclear verdicts, plaintiff counsel will often express gratitude to the jury for holding organizations accountable. And so this is what Bob told me. He said it's their number one theme. And if you can take that theme from them and accept responsibility for something you've done wrong, if you have, or accept responsibility for your product, or for something you've done right, or for your actions, or for the termination of an employee because it was proper. Essentially, being able to take this sort of accountability, I think it's an example of how you can sort of diffuse the inflammation that maybe could be pressed on for the defense folks out there that maybe aren't doing that.
Definitely, I think it's a great point he makes, and just going out that too, what are some things maybe the insurance industry can do to improve its perception in these matters and perhaps lead to different results in the courtroom?
One of the other big points of the apex is personalizing the defendant, which I don't have the numbers in front of me right now, but I don't believe that is done very often by defense attorneys in these cases. So essentially humanizing the defense, or putting them in a different light. I believe in one of the earlier clips, Alan had mentioned just the overall anti-corporate sentiment that his firm had noticed in these cases. So I wish I had the answer, but I suppose just finding ways to work back against that is probably going to be the priority for defense folks here moving forward.
Yeah, actually, now that you mentioned that, it circles back to the commercial trucking story that we talked about earlier on today, and how I think in some cases there, when those trucking companies are facing big verdicts, one way that the attorneys might use that is to as to your point, is kind of trying to personalize it and explain, if this were to go through, then this company would go out of business and it would cost folks their livelihoods, and we generally don't want that. So that's just one example of maybe a successful way that some defense attorneys are trying to really hone in on who's on the other end of some of these huge numbers.
Yeah, absolutely.
Well, we're going to conclude today's video of stories on a situation in California where school districts are facing an onslaught of sex abuse lawsuits after the state rolled back the statute of limitations based off of a 2020 law. AB 218, which was passed in 2020, effectively removed any statute of limitations for when sexual abuse survivors can file a lawsuit against defendants, including school districts. This has led to over 1,000 lawsuits being filed just in the last 4 or 5 years, really. In some cases, schools are able to deliver as far as paying out settlements, but other times they can pretty much flat out bankrupt entire school districts. Some people are saying that this is just an untenable future for California schools. For example, Deanna Rigby, who's superintendent at Carpinteria Unified, a low-income, predominantly Latino district near Santa Barbara, called the payouts unsustainable. She said, these suits are settling for $5 million, $10 million each. We have a $42 million budget. You do the math. Now, Rigby's point is really that these lawsuits, while they are important as far as giving people justice for the sexual abuse incidents that occurred, it's not sustainable as far as, school districts being able to pay out these multi-million-dollar claims year in, year out. Now, there is a bill going through the California legislature right now that would curtail the effects of that bill that was passed in 2020. This bill would reinstate some statute of limitations, as well as providing more ways for districts to issue bonds, to pay off settlements, and to take other steps to give some relief to school districts and other agencies that are facing some of these sexual abuse cases. But it's to be seen whether that bill will go through this session or not.
Yeah, that is another really tough topic. What is the current status of that bill, Ezra, of SB 577?
Yeah, so that bill, which was sponsored by Senator John Laird, again, this bill would bring back statute of limitations and thus severely cutting down on the number of lawsuits that would be filed. The bill is facing, I think, an uncertain future in the California Assembly. There's debate about whether or not parts of it should be amended or repealed entirely. So it's to be seen whether it makes its way through the entire House there, and they have until September to officially vote on this bill and other bills. So we have a few months left before the session wraps up there in Sacramento. This situation in California really explains some of the complexity among the nuclear verdict situation, where on one hand, you want to be able to give people justice, but also doing so in a way that doesn't perhaps rob or bankrupt companies or organizations. And it's an ongoing issue that's still to be resolved, but one we'll be reporting on.
Some tough topics with this topic of nuclear verdicts, but important coverage that you both are doing on this topic. And so I appreciate you taking the time to do this episode with me. And we had to end on a tough one, but, obviously our hearts are with all of the victims and their families. And that's it for our wrap up. And thanks, Alan and Ezra, and everyone who tuned in. We'll be back with another wrap up. If you enjoyed this, and thanks everybody for